Hi everyone, thank you for joining us today for our webinar, The 411 on Elder Law. My name is Kelly Blount and I'm the Program Marketing Specialist here at General Electric Credit Union. We are so glad you've joined us as we have a lot of great content ahead and we wanted to thank you all for tuning in from the comfort of your home, work, or wherever you may be today. With that, I'm going to turn this over to Jennifer Anstaett to introduce herself and take us through today's topic.
Good morning. My name is Jennifer Anstaett. I am an attorney. I practice downtown in Cincinnati. And today we're going to talk about a few different topics related to elder law. So my primary practice is elder law, which means that I deal with estate planning issues, and a lot of issues around paying for long-term care. So we're going to start today on the estate planning side. And so most of what I'll talk about in estate planning will be relevant in Ohio, Kentucky, and Indiana. State law regarding estate planning is generally pretty similar in all three of these states. When we get to the Medicaid portion of the program, if you're not an Ohio resident, take everything with just a little grain of salt because the laws are a little bit different depending on where you live. But roughly, let's start with the estate planning issues. So when you think of estate planning, most people are worried about what is going to happen to their assets after their death. And most people that you talk to have heard that they want to avoid probate. So one of the things that we talk a lot about is what documents you need and how to avoid probate. So when you go to see an attorney to work on your estate plan, they're not just going to ask you, who do you want your assets to go? What should we put in the will? One of the things that they'll probably ask you about is what your assets are, because depending on what type of assets you own affects how those assets are transferred at your death. So when you write a will, when you sign your will and you say, I want everything to go to my spouse and then to my kids, the only assets that is going to apply to are those assets in your name alone with no beneficiary designation. So when you pass away and your loved ones go to probate your will, which just means they take the will to the court, the local probate court in your county, and they file the will for record, and the court appoints an executor, or sometimes it's called an administrator, to look at the contents of your will, see who you wanted your assets to go to, and make sure those assets go to those people. But the only thing that the executor can deal with are assets that are in your name alone with no beneficiary designation. So anything that has a beneficiary designation is going to transfer at your death according to that beneficiary designation. So when you come in to meet with your attorney, the attorney is going to say, write down a list of all your assets and let's see if anything's going to transfer by will or not. So we will go down through all your list, all your assets. Is it held in trust? If your asset is held in a trust, then the trust tells the trustee what happens to that asset, not your will. If you have an asset that's held joint with right of survivorship, a lot of people have their house titled this way or bank accounts titled this way. When you pass away, it doesn't matter what your will says, that asset is going to transfer to the joint owner. Any assets with a designated beneficiary, such as a life insurance policy, an IRA, or a 401k, those are all going to transfer to the beneficiary. Again, doesn't matter what your will says. Bank accounts will often have a pay on death beneficiary. And in Ohio, you can actually put a transfer on death beneficiary on your house or other real estate and on your car. So it could be that when you pass away, none of your assets are in your name alone. They're all either held in trust, they're held jointly, or they have a beneficiary. In those cases, it does not matter what your will says, because you're not going to have any assets in your name alone. So a lot of times when I have clients who come in, we'll go ahead and draft a will for them. We'll draft a will. We want everything to go to the spouse. And then if the spouse is deceased, we want everything to go to the children. However, at the same time, we know that all of their assets are held either jointly with the spouse or they have the spouse as the beneficiary. And we know that everything has a contingent beneficiary in case the spouse dies first. So we know there's probably never going to be a probate estate. We're never going to have to use the will. Now, this is a goal of a lot of our clients to avoid probate. And I do want to say that probate is not the end of the world. It's not the worst thing to ever happen. It does take a little bit longer if you have to file a probate estate. So I would say that most of our clients, it takes about a year to close their estate. In Hamilton County, they would like for you to close all estates in 6 months. That's a little bit difficult. I think most people, it's going to tend more towards a year. You do have to pay an attorney if you hire one. Your executor can charge a fee, and there's going to be court costs. So roughly, I would say in this area, you're going to pay at least $200, maybe more in court costs. So it isn't something that you aspire to do. If you have everything transferring non-probate, things can be done very quickly. Sometimes you don't need to hire an attorney at all. There's no executor fee and there are no court costs. So, for example, if you have everything with a beneficiary, the beneficiary simply contact the bank, they contact the IRA administrator, and they initiate the paperwork to get those assets transferred to themselves. So it's a little bit easier on the family. Now, there are some instances where we don't want things to pass non-probate. We actually want them to go through probate. And sometimes we have families who we need court supervision. We want court supervision because maybe we have some difficult personalities or some arguments among the kids. So sometimes it's not the worst thing in the world to go through probate. Other times, you might have a large family. So you might have, a lot of kids or a complicated family situation. And in that instance, maybe you do want to avoid probate, but you want to also really avoid naming 12 beneficiaries on every IRA or 6 beneficiaries on an account. In those instances, we will often recommend a trust. So think about a trust as a little corporation that you set up and own. And there's 100 reasons to have a trust, but I would say probably the most common one is just to simply avoid having to go to probate court. So in your trust, you name a trustee, somebody to help you or to help your family when you're gone, to split up the assets among your family. So you might pass away and there's a house and a car and some bank accounts. Your trustee would have the authority to sell the house, liquidate all the accounts, and then divide everything up among the beneficiaries. So it acts a lot like a probate estate, except you don't have the court supervision. So when you go to see your attorney, these are the kinds of things they're going to talk to you about. They're going to go through the list of your assets, and then they're going to recommend either just updating beneficiary designations to avoid probate, or they may suggest you go through probate, you actually leave assets in your name alone with no beneficiaries, or they might suggest a trust. But they're going to start with looking at your assets. So this is one reason, this is an example of why it's so important to look at your assets one by one and figure out how they're going to be transferred. So in this case, we have mom who passes away, and she has a son and daughter. She has a will that leaves everything equally to her son and to her daughter. At her death, she has her house. It's in her name alone with no transfer on death beneficiary. She has a checking account and a CD. And when she went to GE Credit Union to set these up, she made her daughter a joint owner, so joint with right of survivorship. And then she has an IRA, and she's nominated a beneficiary. She's nominated her son and daughter. So when she passes away, the executor of her will probates her will through probate court, because the recorder's office doesn't know who to give the house to. So the court issues an order that says the house goes equally to son and daughter. So son and daughter will share the proceeds from the sale of the house. So they'll take a 50-50 interest in the house. That is the only probate asset that mom has. So they will each get 1/2 of the value of the house. The checking account and the CD at GE Credit Union are held jointly with right of survivorship. So those assets transfer directly to daughter. And then daughter and son will fill out all the paperwork they need with the IRA administrator, and they'll each receive $25,000 from the IRA. So the question is this what mom wanted? Because at the end of the day, son and daughter each will receive $75,000 from the estate, and they'll each receive $25,000 from the IRA. So they'll both end up with $100,000. However, daughter is the owner of an additional $100,000 from the checking account and CD. So she actually ends up with $200,000, whereas son only ends up with $100,000. So we don't know if this is what mom wanted. Maybe this is what mom wanted. Maybe she did want daughter to have the money in the checking account and the CD. But that's not what her will said. Her will said leave everything equally. So what mom could have done is she could have listed her daughter on the CD and the checking account as the attorney in fact from her power of attorney. That way daughter could help mom with those accounts, but she wouldn't have been a joint owner. Then she could have listed son and daughter as the 50-50 beneficiaries of those accounts. Alternatively, mom could have set up a trust, transferred ownership of her house, her checking account, and her CD into the trust. That way she would have not only avoided probate, but everything would have gone 50-50 to son and daughter. So you can see there's even in a relatively simple estate like this one, where there were only 4 assets, it can get pretty complicated. So you just have to be mindful when you're going through your estate planning that it's not just enough to sign a will. You also need to look at the ownership and the beneficiary designations of all of your assets. So that is sort of all we're going to talk about when it comes to estate planning. So what I would recommend, what I always recommend, is that you talk to an attorney about this, talk to them about a will, talk to them about a trust, make sure everything is titled correctly so that when you pass away, your assets go to who you want them to go to. All your family will thank you for that. Now, the most important thing that I want to talk about this entire hour is what we're going to talk about next. So when you go to talk to your attorney about your estate plan, you're thinking you're going to talk to them just about what happens when you die, but there's going to be a lot of discussion about what happens when you're alive. What happens if you're not able to take care of your own affairs during your lifetime? So one of the things that they're going to talk to you about is the need for a financial power of attorney, a healthcare power of attorney, and a living will. And the reason that your attorney is going to ask you about these things is because if you're alive, but you're no longer able to make your own decisions, you really need to have appointed someone to make those decisions for you. If you haven't appointed anybody, then there is a mechanism called a guardianship where someone goes to the court and asks to have a guardian appointed for you to make financial and healthcare decisions. Now, the way this works in every state is a little bit different, but in general, these are sort of the definitions that apply everywhere. So the guardian is a person that the court has appointed to take care of you. And depending on the state you're in, it can be appointed to take care of your health or your finances or both. The ward is the person that the guardian is acting for. So it's the person who can no longer make their own decisions. They're also called an incompetent. So it's not a fun designation to have. So in Ohio, for example, there are two types of guardianships. The first is the guardian of the person, and this is where you have authority to make healthcare decisions. There also is what's called a guardian of the estate, and that is the person responsible for making financial decisions for you. Now, each state calls these things a little bit differently. They refer to the people differently. If you're familiar with the Britney Spears case in California, this is called a conservatorship. So that's a little bit different terminology than they use in Ohio. In Kentucky, it's also it's called a guardianship. So, but if you think back to Britney Spears, if you read anything about her situation, she had a guardian called a conservator who was in charge of all her personal and financial matters. So I would say in her case, she got that guardianship terminated. That doesn't happen very often. So there are different types of guardianships other than a full guardianship. So normally when you go to the probate court and you say mom or spouse or child, whoever does not have the capacity to make their own healthcare and financial decisions, the court appoints this guardian to make all their decisions, and it's normally a fairly permanent situation. However, there are limited guardianships where maybe you just need the authority to make one or two decisions. So maybe you need a guardian appointed just to help you sell a house, or maybe you need a guardian just to get you into a facility. That I would think is a little bit rare in Ohio. Normally, most guardianships are appointed sort of on a more permanent basis. There's also an emergency guardianship procedure if you need a guardian appointed right away. The guardianship process takes a while, so you have to have a hearing with the court. to determine that your ward is not competent. And there's also a hearing to determine who the guardian should be. And leading up to this, because you are stripping someone of the legal ability to make their own decisions, there's a lot of notice periods. The ward will be given the opportunity to hire an attorney. If it's a contested matter, so if more than one person has applied to be the guardian, it will be a fairly lengthy process. However, in some cases, you need a guardian right away. And then the court will sometimes grant an emergency guardianship. Normally, where we see these, it's a life and death situation. So if somebody's in the hospital, they're not agreeing to some sort of medical procedure, and the court steps in and appoints an emergency guardian to make a health decision. This is not just mom has dementia and we've never done anything, so we need a guardian. That's not an emergency. In Ohio, we also have something called a conservatorship. It's when someone voluntarily agrees to a guardian, even though they're mentally competent. So it often happens when someone is physically infirm, but mentally competent, and they can't take care of their health or financial decisions. They will voluntarily submit to a guardianship. That's very rare. So here is what you have to do in order to appoint a guardian. First, whoever would like to serve as guardian files an application. The ward is served, so the court will come, let them know that there's going to be a hearing, make sure that they have the opportunity to hire an attorney. The court also makes an independent sort of decision if they think the ward is incompetent. So if they go out to see you and they feel like you're competent, then that's something that the court will raise at the hearing. While the court is doing this, whoever is applying for guardianship, has to have a note from a doctor. They have to fill out in Ohio what's called a statement of expert evaluation that says that this person is no longer competent to make either health or financial decisions. There will be a hearing where the potential ward is allowed to attend with his or her attorney. If the court finds that the person is incompetent to make their own decisions, they will appoint a guardian. So just because you apply to be guardian doesn't mean the person is going to be found incompetent, and it also doesn't mean you're the one who's going to be appointed guardian. So there are advantages to having a guardian. So first, maybe you have a ward in unsafe conditions. So the guardian is going to be able to help remove this person from the unsafe condition. It also may help to protect assets. So if you have a ward who has been, sending their money, to the Prince of Africa because they've won the lottery or whatever those scams are, or they fall for it when some scam artist calls and says, this is the IRS, you owe us money. If that's been happening, or they've been sending money to all these questionable charities that solicit in the mail. So if that's been happening, it's sometimes good to have a guardian step in because they're the ones in control of the funds. A lot of times we see families in dispute, and that's why a guardian is appointed. So everybody knows once the guardian is appointed who is in charge. The disadvantages of this are that can be very stressful for the ward. It can be very expensive for the family to have to hire an attorney and go to probate court. And once you have a guardian appointed for you, first of all, the ward isn't making their own decisions anymore. Second of all, the guardian's not totally in charge either because the state is actually the superior guardian. So a lot of the decision making, especially financially for a guardian, is going to have to be approved by the probate court. And the probate court is probably not going to be making the same decisions that you might have or the ward would have. They're probably going to be a little bit more conservative. So, if at all possible, we tell our clients, we don't want you to have to go through the guardianship process. So what are the alternatives to guardianship? What can we do? So the first thing we can do is a trust. We talked a little bit about trust earlier, but these are sort of little mini corporations that you do it yourself. So there is a document, and that's your trust document, and it instructs the trustee, gives them instructions on how to manage the grantor's affairs. So if I have a trust, I have Jennifer's trust, and I appoint Kelly to be my trustee. And in that trust, I say to Kelly, please use all this money for my benefit. At my death, use all this money for the benefit of my children. That's all a trust is. So if I become incapacitated and I'm no longer able to make my own financial decisions, if I have transferred my assets into a trust, Kelly can step in and make financial decisions for me. Not everyone wants a trust or feels like they need a trust. So the most common way to avoid a guardianship of the estate, so a financial guardianship, is to simply sign a durable power of attorney. So in that document, I, as the principal, appoint an attorney in fact, which is also called an agent, to make financial decisions for me. These are standard documents. They give a lot of authority to the agent, but on the other hand, it's a lot easier if I become incapacitated for the agent to start working on my behalf than it is to go through a full-blown guardianship proceeding. And then the final way to avoid a guardianship really is a healthcare power of attorney. So you need a financial power of attorney and a healthcare power of attorney. And don't think just because you're married that your spouse can make all these decisions for you, because they can't. So just because you're married doesn't mean your spouse can go around making financial decisions for you or healthcare decisions for you. So we always recommend, when our clients come in to meet us about estate planning, definitely they're there to do a will. Sometimes they're there to set up a trust, but 100% of the time, we're going to also suggest a financial power of attorney and a healthcare power of attorney, so that if they become incapacitated during life, somebody's there to act for them, and we can avoid going to the court and having a guardian appointed. So I said earlier, probate's not that bad. Probate really isn't that bad. A lot of people talk about how scary probate is, or how expensive probate, or how hard it is when you pass away. I don't think it's really that bad. It doesn't cost that much. It doesn't take that much longer. It's not the end of the world. Guardianships, however, that's where I really encourage people, if there's any way you can avoid a guardianship, you should, because they really are not a fun experience for anybody involved. They're not fun for the ward. They're not fun for the attorney in fact. They're definitely not fun for the attorney. So it's just so much nicer if you've planned a little bit in advance and you have a good financial power of attorney and a healthcare power of attorney. There's another document that we normally recommend called a living will. The living will doesn't have anything to do with your finances. A living will says, if I'm terminally ill or I'm in a coma, I'm permanently unconscious, I do not want to be kept alive. I want essentially hospice care, comfort care, and I don't want to be on a ventilator or feeding tube or anything like that. So if you feel strongly about that you don't want to be kept alive, then you should definitely 100% sign a living will. In Ohio, I don't think this exists. I know it doesn't exist in Kentucky. I don't think this exists in Indiana. In Ohio, there's also a mental health power of attorney. I don't think it's used too often, but it addresses more specific health issues than a general healthcare power of attorney. So that's that. We're halfway through, and that is all I'm going to talk about on estate planning. So if you don't get anything else out of this presentation, I think the most important takeaway is please, please, please make sure you have a financial power of attorney and a healthcare power of attorney, so that if you're not able to make your own decisions, somebody is there to do that. So that in my practice, I would say the number one problem that arises is someone who has neither of those documents and becomes incapacitated, whether that's because of a health issue like Alzheimer's or Parkinson's, or whether that's a car accident, something tragic happens. Just please, everybody over 18 needs to have those two documents. So what we're going to spend the rest of our time on is Medicaid. So we're going to switch over to what happens to my assets at my death, to what happens if I need to go into either a nursing home or an assisted living facility, or if I want to have care at home. So most people are not able to pay for long-term care on their own because, frankly, it's just too expensive. So a lot of people come to us and say, how do I pay for this care? My spouse or my mother or father are in a facility. How are we going to pay for this? So in our area, I would say in Indiana, Kentucky, Ohio area, nursing homes, there's a huge difference in their cost. Some facilities for assisted living, those are really, you pay for those services a la carte. So you might go into an assisted living facility and you're not paying very much money at all. And then as your needs change, as you maybe get sicker, you need more help, that cost is going to go up. Eventually, many people need to go into full nursing care. Those facilities vary greatly in cost as well. We see our clients coming in with facilities that can range between $8,000 a month up to $14,000 or $15,000 a month, depending on the facility. So there's a pretty wide range. There's also a pretty wide range about how nice these facilities are. So some facilities are very nice, some are not nice at all. You just have to go and check them out. So a lot of people who come to us, again, even at the low end, even at the $8,000 end, or for assisted living $5,000 or $6,000 a month, it's not sustainable to pay for that. So in that instance, we look to Medicaid to pay for that. Now, this is where, in general, Medicaid is the same across the country, but there are differences state by state. So I practice primarily in Ohio. So what I'm going to talk about today is Ohio Medicaid. So again, if you're in Kentucky or in Indiana, take this with just a little bit of grain of salt. So, okay, let's say you have to go into a nursing home. There are two rough areas of eligibility. The first is that you are eligible health-wise. So you have to be eligible for skilled nursing care, nursing home care. So I can't just go to the nursing home and expect Medicaid to start paying for my room and board. I have to meet a certain, what they call, level of care. So most people don't have to worry about this if they're, people aren't going to the nursing home for fun. So usually you're going to meet that level of care. So what becomes the challenge then is if you're medically eligible, that's easy. Are you financially eligible? And financial eligibility is broken down into two categories: your income and your assets. So they look at income separately from assets. So what is income? Income means your pensions or Social Security income. So income that comes to you essentially based on your work record. You can't get it in advance. You can't really not get it. It comes every month like clockwork. So think pension income, think Social Security income. The only other income it would be irrevocable payments from an annuity that you might purchase. We'll talk about annuities in a minute. So if you've got an income stream from an annuity that comes every month, whether you ask for it or not, that is income. And if you have minimum required distributions from an IRA, those could be considered income as well, depending on where you live. So whether you're married or not, Medicaid only looks at the income of the spouse in the nursing home, who we'll call the institutionalized spouse. As long as your income is less than what's called the special income limit, in Ohio, you'll be eligible for Medicaid. This is also the case, I believe, in both Kentucky and Indiana. So this year, as long as your income is below $2,742 a month, you're eligible for Medicaid. If your income is higher than that, you can still be eligible for Medicaid, but you have to jump through a few hoops, which I'm not going to go into because it can get pretty complicated. But just suffice it to say that you have to be a little bit careful if you have higher income, but it's nothing that we can't get around. You just have to be aware of it and jump through a few extra hoops. So a lot of people do have pension income that puts them over this, especially if they've been a public employee. And so it's a little bit harder to be eligible, but it's definitely not impossible. You just have to pay attention. Usually in those cases, I would suggest you do go see an attorney. So once we know that you're income eligible, then we have to look at your assets. And this is where most of the things that you hear about on TV or read on the internet or talk to your friends about are going to be the asset test. So what is that? So when you apply for Medicaid, if you're single, so you don't have a spouse, pretty much all of your assets are going to be countable for Medicaid eligibility. And you will only be eligible when you've spent down your assets to $2,000 or less. So in order to be eligible for Medicaid, a single person can only have $2,000 or less in resources. If you're married, you can keep a considerable amount more. What do they look at? So pretty much anything that you can cash or sell or use to pay for care is going to be an available resource for Medicaid purposes. So Medicaid is going to expect you to use that asset to pay for your care before they will step in. So this is anything in your bank, stocks and bonds. If you have a condo in Florida, anything in trust, usually annuities that are not in payout status, so annuities that you can just cash and get all the money from, The cash value of your life insurance policy. So anything that can be sold and used to pay for the cost of your care is in general going to be up for grabs for Medicaid purposes. So what that means is you have to use that asset to pay for your care before Medicaid will step in and start paying for your care. It does not mean that Medicaid's going to come in and take those assets, or the nursing home is going to come in and take those assets. That's not how it works. How it works is Medicaid just isn't going to pay for your care if you've got a bunch of assets out there that you could use to pay for your care. Now, there are some things that Medicaid does not consider. If you're married, the house will be exempt as long as your spouse lives in that house. One car is exempt. All your stuff is exempt in your house unless it's things that are kept for sale. Your prepaid funeral is going to be exempt, and life insurance with no cash value will be exempt. So if you're single, you're going to have to spend down to $2,000 or less. And unfortunately, you're not going to be able to keep too much. You can keep a car because that's an exempt resource. You can keep your prepaid funeral plan and your cemetery lots. Your house might be exempt, but you're not going to have any way to pay for your bills. So once a single person is on Medicaid, they have to use all of their income to pay the cost of their care before Medicaid will step in. So even though a house might be exempt, you're not going to have the money to maintain it. So usually people who are single end up selling their houses. So if you're single, you don't have a ton of assets that are exempt. But if you're married, there are a lot of ways we can make sure that the community spouse, the spouse at home, is not completely impoverished. So I know we talked a lot about a good list of your assets. This is another time when your attorney is going to ask you for a really detailed list of your assets, because Medicaid, if you go into a nursing home, Medicaid will ask for the value of your resources on the day that you went into the nursing home. So let's say my husband goes into the nursing home on March 1st. If we apply for Medicaid, Medicaid will say, what were your assets as of March 1st? And they mean my husband's assets, my assets, and any joint assets. So we're going to tell them we have a house, we have a bank account, we have a CD, and we have an IRA. The house is exempt because I live there. We'll talk about what happens to the IRA later. It's probably going to be exempt as well. But everything else I have, I can cash in and use to pay the cost of his care. So let's say we have a checking account and a CD, and they're worth $100,000. My husband will be eligible for Medicaid when we have spent down 1/2 of those resources. So if I have $100,000 in countable resources on the day my husband goes into the institution, that's called the snapshot date. So if on the snapshot date we have $100,000, he will be eligible for Medicaid when we have spent $50,000 of that 1/2. So you take your total available resources, divide it by 2. The community spouse gets to keep 1/2, but the other 1/2 have to be spent down. Now in Ohio, the most you can keep as a community spouse is $148,000. So there is a ceiling. there's also a floor of $29,000. So if I have $1 million, my husband and I have $1 million on his snapshot date, I do not get to keep $500,000. We have to spend down to $148,000. On the other end of the spectrum, let's say I start out with 50, I don't have to spend down to 25. The minimum, the lowest you have to spend down is 29,000. Okay, so that's pretty complicated, but essentially where all the interesting part of this is what do we do with that money we have to spend down? So if we have to spend down half or 100,000, we've got $100,000, we have to spend down 50 of that. How do we do that? So the first thing we do is we talk to our clients about what their goals are. So everybody wants their spouse to have, or their mom or their dad to have good care. Sometimes they want supplemental care for mom and dad. They want to know how to pay for that. And almost always, if there's a spouse, they want them to make sure the spouse has some financial security. So those are the most important, in my mind, goals that our clients have. They often are upset about disabled family members, say if they have an adult disabled child, and we can talk to them about helping that person. And only last do we talk about preserving inheritance, but that is a common goal that our clients have. So how do we do this? How do we make sure that our clients have good quality of care and that the spouse is taken care of, and that to the extent that it's possible, take care of kids? This is where Medicaid planning comes in. There's really 3 types of plans that we look at. The first is the easiest. We just use let's say we start out with 100,000, we need to spend down 50 of it. We just pay our debts, we buy our funerals, we buy a new car if we need one. We buy things that the community spouse is going to need. This is the easiest Medicaid planning that there is. There's no tricks to it. If you come in and tell me you need to spend $50,000 to become eligible for Medicaid, I'm going to tell you to buy prepaid funeral plans and cemetery lots. I'm going to tell you to pay off any debts that you have, pay off your mortgage, pay off your car payment, or I might tell you to buy a new car or make home repairs. So very easy. It's very easy to spend down and to go on Medicaid with this type of planning. The other thing that we can do is we can purchase an annuity for the community spouse. And the long and short of this is when you purchase an annuity, you turn resources into income. So you take it out of the resource bucket and you put it into the income bucket. The community spouse gets to keep all of his or her income. So this is a great way to spend down. You have to spend down $50,000. You turn that into an annuity. You buy an annuity with that for the community spouse. The community spouse gets to keep the annuity. The money from the annuity that comes every month, she gets to keep. So that's an easy way to spend down for Medicaid. Then there's also giving a gift. So a lot of people wonder about, can I just give my money away? Can I give the $50,000 away? There are exceptions where you can. So if a child, an adult child moves in with you, takes care of you for 2 years, keeps you out of the nursing home, you can give them your house. You can make transfers to disabled children. So there are ways that you can make transfers that Medicaid is okay with. Usually, though, they're not going to be happy with you if you've given money away. There is a 5-year look back, which you've all heard of. So if you give money away, within 5 years of filing a Medicaid application, Medicaid will not pay for your care for a certain length of time, beginning when you're otherwise eligible for Medicaid. So if I've spent down to my $2,000 because I'm single and I go to apply for Medicaid and I say, oh, I gave a gift within 5 years, they are not going to pay for my care. I only have $2,000 and I've got no way to pay for it. So a lot of people will plan gifts, they'll plan them in advance, or they'll plan them last minute, but with a way to pay for care for the penalty period. It's just something that you need to plan for. So gifts are possible, but it's going to take some forethought. I want to finish up. So with the improper transfers, I'm running out of time. The most, I'd say, safest way maybe to make a gift is to give your money away and wait 5 years. If you wait till the last minute, it's a little bit more complicated. If you want to do this, I would suggest that you contact an attorney, because we normally recommend that you don't just give away your money to your kids, that you would put the money in some sort of trust. We also have all sorts of trusts that we can set up for disabled kids. So if you need to go on Medicaid and you want to give your money to a disabled child, there's lots of trusts out there. So just keep that in the back of your mind to speak to an attorney too, if you happen to have an adult disabled child. Now, the very last thing I want to talk to before we get to the questions, and I only have 6 minutes, is IRAs. And in Ohio, an IRA is exempt as long as you're taking your minimum required distributions. Whether you're 72 or not, you can still take distributions and make your IRA exempt. So if you need to go into a nursing home, or if you're worried about you or a loved one going into a nursing home, I would suggest you talk to an attorney about which of your assets are available and which aren't, because recently Ohio updated their rules that IRAs are now exempt. This wasn't the case a few years ago. So if you're out there on the internet kind of looking around, you may or may not be finding good information. So I've talked, I've got 5 minutes. Kelly, are there questions?
Yes, there are. We'll go ahead and just jump into those with the time we have left. So our first question is, when 2 POD individuals are designated, what happens to the asset when one POD dies before the individual who owned the account in question does? That is, if the owner did not change the POD.
Yes, so that's one of the risks with a beneficiary designation, because you may or may not know what's going to happen. So in that situation, you have to look at the agreement that you sign. So for example, if you put a POD on a General Electric credit union account and one of those beneficiaries dies before you, I don't know what GE's agreement with you says. So you have to actually contact the administrator of that account, or the bank or the credit union, and find out what their paperwork said, because you've actually signed a contract with them and it probably says what happens, and that may or may not be what you actually want. So that's one of the dangers of transferring all of your assets through beneficiary designations, is that something like that could go wrong. So the answer is, what happens, we don't know without looking at the paperwork.
Our next question says, how should vehicles be addressed? Is it wise to go to the BVR and have a transfer of death form completed?
So cars are always difficult. In Kentucky, for example, I live in Kentucky. I have my husband's car and my car both happen to be in my name. It's kind of a disaster because they're not jointly held. If something happens to me, my husband has to probate those cars, which is a pain. In Ohio, a surviving spouse usually can take the cars without going through probate, but kids can't. So in Ohio, they do have a TOD designation on a car. So you can actually go to a title office and have a TOD beneficiary put right on your title. So people handle that different ways. You know, I don't recommend you put ownership of your car jointly with a child necessarily, because there's a lot of liability with that if you get into a car accident. So you know, a lot of people, if they have spouses, they'll just make those cars held jointly. In Ohio, they'll put a TOD beneficiary. So it's really just depends on what's going to be best for you. There's no probably general answer to that question.
Jennifer, do we want to try to get through one more before we come up on noon?
Yeah, absolutely.
Okay, so this question says, what does the term on a general warranty deed mean that states person X and person Y for their joint natural lives, remainder to the survivor of them, his or her separate heirs forever? Does that mean it goes to their children and surviving spouse, or just surviving spouse if one spouse dies?
So yeah, so so if I caught that right, if you've got a deed that's with another person and it says jointly with right of survivorship or words to that effect in Ohio, that means if you pass away, ownership transfers to the joint owner. It does not mean it goes to heirs. So like if it says heirs forever, that language, it's not going to your kids. So when both of the owners pass away, for example, it would have to go through probate. So depending on what your deed says, you know, hopefully most people's deeds, if they're married, in most cases, I guess, probably are jointly held, but you don't really know until you actually look at the deed. If it just says like my name and my husband, Jennifer and Patrick, period, it's not a jointly held asset. And at the first death, it would have to go through probate. So I'd have to look at your specific deed to tell exactly what would happen when you pass away. But that is something to consider, like go through that pretty carefully so that you know exactly what will happen to your house, because the language can be pretty tricky. Just an and. Just Jennifer and Patrick doesn't do it. It doesn't make it a jointly owned house. So it is a little tricky.
All right, so we have come up on our time, so that is going to conclude today's webinar. Thank you all for joining us and have a great rest of your day.